Welcome to our fourth lecture regarding our Module 1 material. So in our last lecture, we talked about the various definitions of employees and the various tests that we use, specifically the Economic Realities Test, the Common Law Agency Test, and the IRS 20-factor analysis. We also talked about how some statutes sort even more than putting workers in the independent contractor category versus the employee category. Some statutes actually sort more and segregate within that larger category of employee, and will segregate non-supervisory employees from supervisory and managerial employees. But as we decided, theory is great, but it only takes us so far. We have to see what happens in the real world when these concepts are going to be applied. So in the next several slides, we're going to go through some scenarios. Some are literal cases from real life, and some are made-up cases, but they'll both kind of illustrate our point. So let's get started. Our first case is Lemmerman. This is a real case. It's from a pretty long time ago. The owner's from North Carolina, so obviously, you don't need to know about this particular case. I'm not going to test you on this case. It's designed just to give you an example about how these things occur. In this particular case, we have an employee, the mom, we're going to call her Susan, I don't know what her real name is. She worked at a convenience store, probably as a clerk.
Yeah,
I guess the mom was the clerk, actually, and then she had a son named Shane, who was 8 years old. Mom couldn't get a babysitter, so the owner of the, probably just the manager of this convenience store, allowed Shane to hang around the store while mom worked, and gave him some, a little bit of money to, sweep and do a couple of other tasks. My guess is, and I don't know this for certain, but my guess is that the boss was doing Susan a big favor and was kind of treating Shane a little bit like an indulgent uncle by letting him do a couple jobs and giving him some spare change, maybe letting him get some money to buy some candy in the store. And anyway, what happened was that this was obviously not a child care center, and so Shane's 8 years old. He probably got into a little bit of mischief, and he cut himself. And I guess it was a pretty significant cut. And as a result, the mom sued the business over Shane's injury. And the response of the company was that, well, gosh, Shane was an employee, and so therefore any claims that Shane, the 8-year-old, can file would have to be through the state's workers' compensation benefit. The mom said, no, Shane wasn't an employee. He was just like a customer or somebody else who was there. And under those circumstances, it would be possible for the mom, or Shane, and essentially the mom, to get a significantly larger award, because there are limitations to the types of recovery that employees can make that don't apply to the recovery that customers can make. We'll talk more about how workers' compensation works later in the course, but just take my word for it now that it would be a good thing for Shane's mom if Shane were not an employee, but was instead just a customer, a business invitee. And it would be good for the company if Shane were an employee in terms of this particular risk. Now, you might think off the top of your head, well, that's just crazy to think of an 8-year-old as being an employee. I mean, he obviously is too young to work under the Fair Labor Standards Act. Certainly, various payroll taxes weren't being withheld from his quote-unquote pay. And I'm sure he didn't complete an I-9 form on his first day of work. So there were lots of things that would lead one to conclude that he really wasn't an employee. But the state Supreme Court said, yep, he was. That was the most clear example of an employee under those circumstances. This statement here, this is the holding. And when you see these examples going forward, they will fit the same example. We'll see the issue first of all. Does a court have the power to hear a dispute when the statute specifically provides for a non-court remedy? The answer is no. So in this case, what is the non-court remedy? It's the workers' compensation process. And this is, when I say it's a non-court remedy, there is a tribunal that hears these cases, but they aren't the normal state court system. They're a system that's set apart from the normal courts. So the legislature in North Carolina has set up this process, and it's a process that probably exists in all 50 states. And if you're an employee, this is the process you have to follow if you have an accident that's work-related. And so the issue is, does a court have the ability to avoid this process in this case, in Shane's case? And of course, the reason they would be able to avoid it would be that Shane is in fact not an employee. And in this case, because they found that Shane was an employee, then you'd have to find that no, the court could not bypass the state process. And then after I identify the issue, and oftentimes I'll put the answer in parentheses if it's a yes, no type answer, then I'll describe the facts. And then oftentimes we'll have a section which talks about the procedural history. I don't have that in this case. And then in this case, I have a section I don't usually have, which is the employer's position. And then we end with the holding, and that is, a court must refrain from exercising jurisdiction when a worker's status is that of an employee. In other words, workers' comp cases don't go through the normal court system. Now, it is my opinion that what is behind this decision is that the court kind of concluded, hey, mom's getting a little graspy here. She has a boss nice enough to let her bring her kid to work, nice enough to even let the kid do a little bit of odds and ends for some pocket money. And when the kid gets into some mischief, she wants to blame the employer for it. That's my guess as to the backstory here. Could be completely wrong. But the designation of Shane as an employee seems a little bit over the top. But you can see in this case, when you have even a hint of employee status, courts oftentimes latch onto that. Now, in this case, it's not good for Sean to be an employee. It's important to, it would be better for him if he were an independent contractor. But in most cases, the opposite is the case. The worker wants to be an employee. That's the advantageous position for the employee or the worker to have. So again, you don't need to know this case. This is just an example that I want to expose you to. So here we have another example. So we have this company. It has 2 employees, probably has a lot more than 2 employees, but one is Bob and one is Larry. You'll see in my stories, I have lots of Bobs and Larrys. So Bob is hired as an employee, but Larry is hired as an independent contractor. The thing is, though, they do the same stuff. They both work a standard work day, 5 days a week, 40 hours a week. They work in the same office. They have the same boss. They do the same job. So all of this sounds basically like they're doing the exact same deal. All of this is the same between the 2 of them. But here we get into some differences. Bob is paid a salary. After all, he's an employee. And of course, Red Panda does all the required withholdings and all the deductions and makes all the payments that it has to with respect to Bob. But Larry isn't paid a salary. He's paid on a project basis. And of course, because he's being treated as an independent contractor, there aren't any of these withholdings. Plus, he doesn't get benefits. In this case, it's very obvious that Red Panda is in violation. And in fact, by designating Larry as an independent contractor, it is in violation of the Fair Labor Standards Act and probably a number of other laws. Now, you might be thinking to yourself, oh, some small company might do something like this. It used to be common for larger companies to do this. In fact, it's pretty famous. Microsoft is pretty famous for having done this once upon a time. I'm sure it no longer does this because it got its hand pretty severely slapped for engaging in this behavior. But this is not something that has happen only infrequently. These types of shenanigans at times have been very common in corporate America, and I'm sure there are still some holdouts. Let me pause here and give a little bit of discussion about how to handle these issues when they come up. If you have a client who is doing these types of things, where there is just no argument that the person they're identifying as an independent contractor is in fact an independent contractor, you don't need to be the heavy. Your job is to let the attorney know what's going on. It's the attorney's job to deliver that bad news to the client, to figure out the best and most effective way of communicating it and who to communicate it to. So don't feel like this falls upon you. Yes, it may be your role to identify the issue, to research the issue and present that research to the attorney, but it's not your job to try to persuade the client that it ought to adopt a different approach. So getting that regular communication with the attorney is so important when you're seeing some things along this line. Lack of compliance with the law, and in fact, in this case, would be pretty unethical behavior on the part of the employer. Here we have another situation. Okay, so we have Bob again. This is a different Bob. Bob works as a trainer, and it's pretty common for trainers to be independent contractors, especially if they're supporting smaller companies that don't have the staffing to support a full-time trainer. So he's paid a set amount for every session. It's not by the hour, so that's an indication of independent contractor setup. He's traveling from location to location. Now, it's certainly the case that employees can be required to travel from location to location. But the fact that he does that is one indication that he might be an independent contractor. And this is especially true when he's using his own vehicle and he's not being paid a certain mileage situation. And we can see he's not being paid a certain mileage situation. He's just being given more money, a flat amount, $150. Maybe it only costs him $50 extra to travel to one location. Maybe another location it costs him $200 to get to that new location. But the company gives him a flat fee for that. So the fact that he's not getting his mileage is an indication that he's an independent contractor. Another big indication is that he prepares his own training material and he provides it. He's making the copies. He's, giving the booklets or the videos or whatever the training supplies are that he's presenting to the workers that he's training. He's providing all that out of his own budget. So in these situations, he has multiple clients. I mean, Kangaroo is one of his clients, but he also functions as a trainer for other companies. This might be the single most important fact. And of course, you want to drill down and figure out, well, how many other companies is he a trainer for? What percentage of his income is from Kangaroo? All of those would be relevant. Given this information, though, I would say that it's pretty likely Bob is an independent contractor for Kangaroo Systems. So that seems to be where the facts are heading. But there are the facts out there that you want to do some more research on. As I said before, these cases are very fact intensive, and you're not going to be able to capture all those facts in a single paragraph. So if you happen to be charged with doing this analysis, yes, look at your 20 factors, look at the common law test to come up with lists of questions to ask. And there's going to be a lot more than 20 questions to ask. So you can drill down into the minutia and figure out all the things that you need to figure out to get as full a picture of Bob's employment as you can. Here we have another case. This one's kind of one you may have heard of, especially if you're a more mature person. Back during the Super Bowl one year, Janet Jackson and Justin Timberlake performed. While they were performing, they had what they called a wardrobe malfunction. And if you are interested, you can actually go to this link, if it's still up, and see the performance. During this performance, for a brief period of time, Miss Jackson's breast was exposed, less than about half a second, I guess. And it was very, very shocking. This was the news cycle just completely was about this for quite a while. Anyway, the FCC, which is the Federal Trade Commission, fined CBS a significant sum of money because it violated broadcast decency standards, because of course CBS is a broadcast station. It's not just something on cable. And CBS issued an apology. They said, hey, we didn't know that that was going to happen, because Ms. Jackson and Mr. Timberlake were independent contractors. They came up with their performance, they scripted it, they hired their own staff, and so we were pretty far away from that. Now you might say to yourself, well, if they were your agents though, if they were independent contractors, aren't you still responsible for it? You know, you can be responsible for it, as I went through the examples with the real estate agent, but you have a better argument to say that they are independent contractors. And that's especially the case when you can say that someone is an independent contractor who acted for a limited purpose, that the scope of their role was limited to a particular situation or particular set of expectations. And that's what the CBS argued. And so they were able to find that, yes, they didn't have to pay the fine. You know, a fine's a little bit different thing than if as a result of Jackson's and Timberlake's performance, someone had been injured. If they were suing CBS, CBS would have had a much less strong argument that they were not responsible for Jackson and Timberlake's performance. But a fine is really, vicarious liability really isn't as much in play, because the idea is here is, did employees of CBS know this was going to happen, or were there where there's a good likelihood this would happen? Because this is designed not so much to compensate a plaintiff, but to punish a wrongdoer. But if in fact it was Jackson and Timberlake who were the wrongdoers and CBS was kind of being duped by them, then there really wasn't as much of a reason to fine CBS. Although you could still argue, well, if CBS knows they might be fined, they might supervise the performance a little bit more closely and the dress rehearsals and things like that. But you can see how in this case it was important to CBS that Timberlake and Jackson were independent contractors versus being employees. And you can see the things that they look for is they did their own choreography, they had a lot of discretion about how to do it, they selected their own performers, they hired the choreographers and the dancers, and CBS wasn't involved in it. So it looks like that, yes, in fact, Jackson and Timberlake were independent contractors. So we've talked about what the standards are for deciding what an independent contractor is. We've looked at 3 different tests. We've also looked at several examples of how some real life situations, how courts have decided whether someone is an independent contractor or not, and then some scenarios, pretend scenarios. But let's kind of get a little bit more focused on the business angle to this. Many times paralegals will work directly for corporations, and so you are oftentimes dealing with the business people, and you need to understand what they're thinking about, what motivates them, and you may also be asked to share some of these motivations with them, because after all, businesses are here to make money. So it's good to understand the rationale behind why companies think about using independent contractors or labeling workers as independent contractors versus employees. And so here are some common reasons why that happens. The first of all is that they may have specialized skills that are hard to find in the employment arena. You know, wouldn't it be pretty difficult for you to go out and hire a brain surgeon to be your employee? You don't have enough work for that person to do, and guess what? Brain surgeons earn a lot of money. It doesn't make sense to put that person on your payroll because they have very specialized skills, and you don't need a lot of those skills. Plus, you don't need those skills for very much time. So when somebody has very specialized skills that you don't need for a very long period of time, the independent contractor scenario is about perfect. Another reason that people like independent contractors is that they can be cheaper to use. You don't have to pay overtime. If an independent contractor works 100 hours a week, you don't have to pay overtime after the 40th hour because they aren't your employee. You also don't have to pay overtime. If you hire somebody $500 to do a project and it ends up taking them longer than they expected, you, the hirer, aren't on the hook for additional money, as you would be if you were the employer, because you're probably paying people on an hourly basis. So you're paying based upon the output, not based upon time, not based upon the needs to hire additional people or get more equipment or things along those lines. There is also some reduced risk for mistakes made by independent contractors, as we saw in the Jackson and Timberlake situation. Now, an employer shouldn't count on that because many times an independent contractor's mistakes, the principal will be responsible for. But there's at least an argument that the principal wouldn't be responsible for it. That's a much more difficult argument to make if the worker is in fact an employee. So it helps. It's not a magic pixie dust which you sprinkle over a situation and remove all liability, but it can at least present you with that argument. The hirer is not liable for most torts committed by an independent contractor within the scope of the working relationship. That's a general rule, but there are some notable exceptions to that. And then, of course, there are other work-related expenses, such as insurance, that you're going to have to provide for your employees in some cases, that you don't have to provide for independent contractors. And there's obviously reduced tax obligations. You don't have to do withholding. Of course, that doesn't cost you money, but you don't also have to pay your share, the employer's share of Social Security and Medicare, as well as workers' comp and unemployment benefits. Those taxes are by no means trivial, and so they're definitely something to consider. Obviously, the independent contractor still has to pay those taxes, especially the federal income tax, but it all becomes his or her responsibility to do so. Now, as a result, it's not unusual that employers, or principals end up paying independent contractors more money up front than they would pay an employee, because of course the employee is getting all these benefits. So it's not that it's 100% profit because you're paying some of these taxes. Let's consider two scenarios here. So we're back to Bob, and this is a new Bob. This Bob is an independent contractor. He performs auditing services for a bank. And we know that he's an independent contractor, so we're going to accept this at face value. Because he's an independent contractor, the bank isn't going to withhold or pay into the various taxes relating to unemployment compensation, FICA, or other taxes along those lines. So the bank is experiencing a saving. If it at some time in the future decides to hire Bob as an employee, even a part-time employee, then it's going to have to start doing these withholdings and these extra tax payments. So now we have Bob again. This time he's an independent contractor for a law firm. Under these situations, he's going to have to make these payments, and the law firm isn't going to be responsible for making those payments. And Bob will need to continue to do this. The bank will issue for Bob a 1099. That's the tax form for independent contractors, and some other situations as well. So the IRS is going to know the amount of money that Bob received from the law firm, and is going to know there weren't any of these withholdings, so it will fall upon Bob to make those payments. So those are some of the reasons that principals like to use independent contractors. Another reason, of course, is the benefits. Typically, independent contractors do not receive employment-related benefits like health insurance or vacation time or things like that. And in fact, if you are going to make the argument, or you plan to make the argument that a person is an independent contractor, you don't want to pay them these benefits, because that's a pretty strong evidence that the person is an employee. And again, that's one of the reasons why Microsoft got into so much trouble, because it was having these independent contractors work for extended periods of time and yet they did not ever become eligible for employment benefits. Let's consider this scenario. So we have Mary, she's an accountant, and she works for is hired by Pug Industries to do some auditing work. She comes in the office when needed and is paid $700 a day for her services. So it looks like she seems like she's probably an independent contractor in this situation. Again, you'd want to find out exactly how many other clients she has, how often she's needed, how many days her services are requested. But if all of this checks out, then it is true that Pug is not going to have to withhold taxes. And similarly, Mary isn't going to be able to sue for retirement benefits or medical benefits or vacation benefits. One thing I want to clarify here is that I use the term hire to refer to both hiring independent contractors and employees. That can get a little bit confusing. Just be aware that usually this term has a broader meaning than hire for employment. You can hire also for independent contractor status. Another benefit to independent contractors, although I don't think this is one that employers usually focus on, is that discrimination laws and laws like the FLSA and the NLRA don't apply to independent contractors. They only apply to employees. And so you can legally discriminate against independent contractors, or at least you're not violating Title VII and the related laws. There are other laws that do prohibit some discrimination, but they are more difficult to enforce, and they're somewhat more tricky to kind of manage. So usually an independent contractor is not going to be as successful advancing a discrimination claim as an employee might. Let's consider this scenario. So Eel Company solicits bids from independent contractors to maintain its grounds. It's a landscaping, basically, bid. The CEO decides he will not accept any bids from Asian contractors. He does actually get one, and he rejects that bid, but he doesn't have any legitimate reason for doing so. Well, naturally, the contractor is pretty unhappy once he hears about this, and he sues the company for discrimination. Well, this is an unlawful action that the CEO has committed, but he hasn't violated Title VII because the Asian contractor was not applying for a job at Eel. He was seeking to become an independent contractor. So it's not a violation of this law, although it is a violation of other laws. So it's not that it's lawful behavior that the CEO engaged in, but I'm going to be honest with you. As a practical matter, probably the Asian contractor is going to be out of luck, or at least it's going to be more tricky for him to advance his rights. Okay, so let's talk about a related concept, and we'll talk about this in more depth in later modules, but I want to touch on it now. Sometimes employers will hire people through temporary agencies, and there's lots of different ways that this happens, but one way it happens is that an employer might say, I want to use a placement service. And maybe I'm planning on only hiring people for a peak season. Maybe it's a Christmas hire time, or maybe summertime. Maybe I work in or manage an amusement park, and my peak time is the summer. And so I'm only anticipating I'm going to need these people for 3 months, and so I might choose to have a hiring service hire those folks. And maybe as part of that situation, if say Bob is hired by this temporary agency to work in my facility, and I conclude that Bob is a really awesome worker, I may well have the ability to transfer him from the employment of the temporary agency to my employment directly. So there's lots of different ways these relationships can develop. But let's say that when I have this amusement park and I'm hiring my summer help, and I say to the agency, well, this is supposed to be an amusement park. Nobody wants to see a bunch of old people. So don't hire anybody over 30. We don't want to have those category of people working here. Well, that would be unlawful because under the Age Discrimination Employment Act, an employer can't discriminate against people who are over the age of 40. And so all the potential applicants who are 40 or older would have a claim of discrimination against the amusement park. Now you might say, but the amusement park isn't the actual hirer or employer of these workers. It's really the temporary agency. Well, in this particular scenario, the temporary agency is in violation of law. They don't have the argument, or it's not a winning argument at least, to say, oh, well, we're only doing what our client wanted us to do. Our client's the bad guy, we're just following orders. I mean, it didn't work for the Nazis, it's not going to work for the temporary agency, right? You can't say, I was just following orders and expect, if the order is unlawful, and expect the court to not find you liable for it. So the temporary agency would be liable, but not just the temporary agency. Also, the client, the actual amusement park would be responsible. So again, let's say I'm a 50-year-old applicant. I'm not offered a position, even though I have extensive experience in this industry. I sue the temporary agency and I sue the amusement park. Guess what? I can recover from both. Oftentimes, the temporary agency may not be a very deep pocket, and so I may not find that that has a lot of financial resources for me. I may want to focus on suing the amusement park. So the bottom line is you can't use a temporary agency to avoid ultimate liability when you are the person who is suggesting an unlawful policy. Now, of course, most of the time in those situations, the client isn't going to be that direct. Don't hire anyone over 30. I mean, that's very blatant. It's going to be a more subtle thing. You might say things like, you know, most of our customers are young people and we want to have a playful, young, fun atmosphere where people are just feeling like it's a party and that feeling. And so we want employees who can, you know, have that vibe, the kind of people who might just start dancing in the line and encouraging people and just high energy, high pep people. And the temporary agency might interpret some of those words to be codes for we want young people. And so under those circumstances, the amusement park could be on the hook even if they never directly said don't hire anyone over 30. Okay, so usually it's not a bad thing when an employer classifies an independent contractor as an employee. I mean, that's not a bad thing because an employee is going to have more rights and more benefits than an independent contractor. The risky side is when the employer takes somebody who should have been an employee and identifies them as an independent contractor. So the advantages we've already discussed to being an independent contractor. We've kind of documented those in these slides. Starting here with slide number 40, 41, 42, 43. But the downside, the reason that you don't want to identify people as independent contractors when you're in that gray area is that there's significant risk. If the court disagrees with you, you can be in a world of pain. Well, what kind of pain? You might ask. Well, let's look at the pain that you might experience. You potentially violate tax laws. If there's a union organizing campaign going on, you would violate the NLRA. If you are not paying overtime to these individuals or you're paying them the equivalent of something that falls below minimum wage, there could be an FLSA violation. There could be an ERISA violation if you're violating people or denying people certain benefits that you provide to your employees. You're not doing the withholding and you're not doing the employer contribution to FICA, and you're not paying in workers' compensation or employment benefits for these individuals. All of these are violations, and when the government figures out that they're not getting all the money they want, they're going to want the money they're missing out on, and they're going to very likely want to fine you. The fines can be very, very substantial. Under the FLSA, there can be a $10,000 fine And I believe it's by employee and maybe even by the day. And it can even result in prison time. That's pretty rare. I'm not going to lie to you. You have to have pretty dramatic facts. But, it's good to know what the risks are before you get into that situation. And again, there can be a penalty of up to 20% of the FICA taxes that should have been withheld and that weren't withheld. So, again, there are very significant consequences here. As a result, most employers, if you're in the gray area, you really look at it and go, gosh, I just don't know which way a court would go. Most employers, most conscientious, conservative, cautious employers, when I say conservative, I don't mean politically conservative, I mean conservative in terms of making good, cautious decisions. Those employers are likely to err on the side of designating people as employees. So let's talk about a safe harbor. A safe harbor is a concept that you will oftentimes see in the law. And the idea, of course, is that imagine you have a port city and they have dredged the harbor so that all the rocks and all the obstacles in the harbor have been removed. So it is a place that ships can come into and not worry about getting grounded or having damage to their hull or things along those lines. It's a safe place for them. And we have these types of ideas, these safe harbors in the law. And what will happen is that in legislation, the legislators will say, listen, we know that we're maybe not being as precise or giving you a really easy rule to follow. And you know if you're safe, you know if you're not safe. So what we're going to do is we're going to say, here, let's say this is all the things that can happen. And if you're on this side of this line, you know you're safe. You're on this side, you're unsafe. But there's a lot of area that it's hard to know. There's all of this area right here that's kind of gray, and it's hard to know if you're in the safe area or the unsafe area. And so what the legislature will do is say, listen, we're going to give you a little island here. And if your facts are just like this, you are in a safe harbor. I'm kind of mixing metaphors by talking about harbors and islands. But if your facts fit into this category, you're just as good as if you were in the absolute safest territory ever. So let's look at what the safe harbor is that we have for this one. Again, this is a definition of a safe harbor, so this is one you likely want to add to your Quizlet. And this is the definition right here. So this part up here. Your definition. So this is how an employer can satisfy the safe harbor. Now you can still be, so in this case, if an employer satisfies all these requirements, then that worker is definitely an independent contractor. This isn't the only way you can prove that. There can be lots of other ways that you can also have an independent contractor. But this is one way that if you meet all these, you know that you're safe, okay? So keep in mind, this isn't the only way, it's one of the ways. So first of all, the business must never have treated the worker as an employee for any purposes or for the purposes of employment taxes for any period. So if there's a single time, it may have just been a bookkeeper making a crazy error. If that happened even once, even 20 years ago, you don't have access to the safe harbor. It can never have happened. Even if you corrected it later on, the one-time event means you don't have access to the safe harbor. The person may still be an independent contractor, but you're not going to be able to use the safe harbor to prove it. The next one is all federal income tax returns with respect to this worker were filed consistent with the worker being an independent contractor. So you've been doing 1099s for this worker throughout the time, every single year, doing all of those things. Again, you missed a year. If that person worked during that year, you're not going to have access to safe harbor. They may be an independent contractor. You may be able to prove it, but you can't use the safe harbor. The company has treated all of those in a position substantially similar to this worker as an independent contractor. And that's just generally an important rule. If people are doing the same stuff, you need to treat them all the same way unless there are material differences. And you can see situations where it might be. For example, you might have different facilities. In one facility, you have janitors, because it's a very large facility, janitors who are employees. You have another facility that's much smaller where you have janitors who are independent contractors. But that makes sense. I mean, even though they're doing the same janitorial work, the number of hours that they're working and the level of direction that they're getting is going to be different. And so when it's substantially similar, you ideally want to either treat the people the same, or you want to have some really strong reasons why you're treating them differently in terms of employee status or independent contractor status. And then this is the last one. And this one you might say, well, gosh, this is so vague. How does this create a safe harbor? And you raise a good point. The company has a reasonable basis for treating the worker as an independent contractor. Again, we're going to review the 3 standards that we looked at before. And if it looks like that the vast majority of the evidence falls in the independent contractor status or category, then you're going to fit into the safe harbor. This one's a little bit loosey-goosey, a little bit imprecise, and so this safe harbor maybe isn't as well constructed as the ideal safe harbor may be. So these are just some things to keep in mind as you're considering and giving advice to your clients about whether you have an independent contractor situation or an employee situation. Okay, so as we said before, the risks here are pretty darn high. Most employers are concerned about reducing the risks, especially when you have lots of incumbents in the position. I mean, if you only have 2 or 3 people in this particular position, it's not super risky. If you have 1,000 people in this position, you're talking about millions of dollars of risk here. And so, there are levels to identify in terms of the risk. So one way to reduce your risk is going to be to document the independent contract status. You're going to create documents that support this version of what you think reality is. And your guiding principles are going to be these things that we talked about earlier when we were looking at these goals. You're going to have things in the document that say, this worker is responsible for his own training. He's responsible, or she's responsible for hiring the own assistants. All of these things that make it seem like it's an independent contractor. But as you can see in this example, if it's a duck, if it quacks, it's a duck. So you're not going to be able to create documents that take what is really just a traditional employment relationship and make it into an independent contractor. The court's not going to buy it. These documents that support it being an independent contractor can move the arrow slightly. If you were in the gray area, remember our continuum from an earlier lecture, and you're in this gray area here, having some good documents that support the idea of independent contractor versus employee might move you from, say, here to here. But it's not going to move you from here to here. And so keep in mind, have realistic expectations about what these documents can do. Because if it looks like this and it's saying quack, quack, it's an employee, it's a duck. Okay. So again, this is the quack argument here. So when you are hiring somebody who you feel really is an independent contractor, having that agreement set up to highlight that independent contractor status can be very helpful. And it can be helpful not just in terms of independent contractor status issues, but also just generally. It's a good idea for any kind of contractual relationship because, hey, I thought you agreed to prune the shrubberies, the landscaping company. Well, that wasn't in our contract. We were just going to cut the grass and treat the weeds. So the more you can be specific about the roles or responsibilities can help you avoid misunderstandings, and again can help avoid findings that a person was an employee instead of an independent contractor. So here are some things to keep in mind as you develop this contract with an independent contractor. You want to specify and agree that the independent contractor is going to provide his or her own tools and is going to pay his or her own business expenses. You might say, well, there aren't any tools necessary for this particular role. Let's say the person is being hired to be an auditor, and all he needs is a pencil, or something along those lines. Still, make him provide his own pencil. I mean, it may sound silly to not let the guy borrow a pencil, but it is a good thing to have it in the contract and to actually follow through and say, well, you need to provide your own pencil. Or, I'll let you use a pencil today, but be sure to bring your pencil next time. You want to be specific about this. If there are going to be assistants, then you want to specify that. It's even a good idea to specify even if there aren't going to be assistants, because, again, this would be evidence that there is an independent contractor situation. And you should work towards a flat fee for the work. Hourly rates are not as good. Now, they aren't terrible, but they aren't as good as a flat fee arrangement. So move towards that situation. Even daily rates are better than hourly rates for an independent contractor situation. Now, in many businesses, you're going to find, if you work for a large employer, that there are lots of independent contractors running around. And the reality is that many of these arrangements don't get, the legal department doesn't even know about them. So you may find that you have to do a bit of triage here. You have to focus on the ones that are most at risk. And in this situation, the ones that are most at risk are going to be the longer term arrangements. I've worked with clients in the past that have a hard and fast rule that no independent contractor can work more than 6 months. Even if they're awesome, they have to either transition to employment or they have to say bye-bye. Some employers have a rule of 90 days with a possibility of an extension to 6 months. Both of those standards are pretty common in the industry. And the neat thing about having a time limit is that it's easy to apply. And so if you have non-legal professionals who are managing some of these aspects and may not be fully on board with all the details of what separates an employee from an independent contractor, everybody can get out a calendar and count out 90 days or 6 months and apply that rule. One thing, if you have a rule like this, you need to be very, very strict about it. You don't make exceptions. You apply it even if you're in the middle of that project. Again, if you don't want to follow that, then you just switch the person to employment status. So there's not really a very good reason to not apply that rule strictly. You also don't want your independent contractors to do the same work as people who are labeled as employees. And you don't want them working together, having the same type of office, having the same type of equipment. You don't want to assign them a telephone number. You don't actually want to assign them an office space if you can avoid it. You don't want to give any kind of benefits, even small benefits like a parking space with a name on it or things along those lines. Things that feel like things that employees get. You want to encourage your independent contractors to offer, market, and actually have services that they provide to other businesses. So when you're in the process of selecting your independent contractors, make sure they actually have a business going on. And you may want to actually have that documented in the agreement. Independent contractor, agrees and states that he or she has other clients, Again, you want to limit your training for these individuals just to what is needed to maneuver in that work environment, how to use the badge system or whatever. You definitely don't want to offer the independent contractor training in his or her field. So let's say this is a computer independent contractor. You don't want to have this person attend training that your computer programmers might be attending, because an independent contractor, it's not your responsibility to train him or her. And of course, if the independent contractor needs some assistance, needs some training, for example, it's his job to pay for it. It's her job to find it, to decide which one of the sources he or she is going to use. You shouldn't be in a position as the principal to be saying, you need to go to this training, or this is what we recommend for you. And again, stating all these things in the agreement is a smart approach to reducing the risk of a finding of employee status. Keeping in mind, the agreement isn't going to solve an inherent problem that may exist if the person truly is an employee. So we have finished the first bullet under our worker as an employee or other, and we've sorted through whether the person is really an employee or an independent contractor. In our next lecture, we'll talk more about temporary or leased employees. I thank you for your attention, and I hope you have a wonderful day. Take care.